Thank you, Dean Raymond. I am truly honored to be here today to give this talk. I want to tell you that it's rare that I have spoken at the law school since I graduated in December of 1974. And I want to tell you what happened the last time I actually addressed a group, not as a teacher because I have taught here. I actually addressed a group. It was when it was in my first year of law school, and it was a faculty meeting, and there was an issue that had to do with students who wanted something, and I was chosen to make the presentation. So I got up and I made the presentation, and a very well-known professor, who I won't name, said, "That was really insolent." So in preparation for my talk today, I looked up the definition of insolent, and to be insolent is to be rude and disrespectful. And then it said use insolent in a sentence, and it said talking back to a teacher. So I thought, okay, he used the right word. I probably was insolent, and I thought this is probably a good way to start out to be a lawyer. That it's really a good idea when you are representing someone to be willing to speak truth to power, because your clients are powerless without the help of a competent attorney. And for those of you who are students here, keep that in mind. For those of you who are lawyers, I think you understand what I'm talking about. People depend on us to advocate for them and to do it in a way, maybe not in an insolent way, but to do it in a way that protects their rights. What's really fundamentally important is that we as lawyers have an obligation to justice. We have an obligation to take steps in our professional and our personal lives to ensure that this is a more just society. And in the practice of law, which requires us to make a living, requires us to look out for all kinds of rules and regulations, requires us to be respectful to judges and to other lawyers, we still have to remember that justice is what we should pursue. That's what I learned at the University of Wisconsin Law School, and it's a pleasure for me to be here and address you from that point of view. I came to the University of Wisconsin in 1968. I went to law school because my then girlfriend, now wife of 47 years, after I was complaining about a job that I had and I didn't want to be bossed around, she said, "Why don't you go to law school?" I said, "Oh, okay." That's a true story. It happened right on Park Street by the Humanities Building. But I think it was the right decision. My topic today is the danger of an Article 5 constitutional convention. Article 5 is an article of the Constitution that we generally don't pay attention to. It's about amendments to the Constitution. So we know that the Constitution can be amended if Congress passes by 2/3 vote of each house a proposed amendment. And then that amendment is submitted to the states, and the states, if 3/4 of them approve it, the Constitution is amended. There is another provision in Article 5 which talks about a constitutional convention. And a constitutional convention can be called if 2/3 of the states pass a resolution asking for a constitutional convention. As of today, 27 states have passed such a resolution, which means we are 6 states short of a constitutional convention. Nobody knows what will happen if those 6 additional states pass resolutions calling for a constitutional convention. There has only been one constitutional convention. It didn't start out as a constitutional convention. because there was no Constitution. There were Articles of Confederation. And a whole bunch of, actually it turns out pretty young, fairly well-to-do white men got together to change the Articles of Confederation, and lo and behold, they decided to scrap the Articles of Confederation and come up with our Constitution. They didn't have any authority to do that. The states that sent them to amend the Articles of Confederation didn't tell them to do it, but they did it. And there are no rules for a constitutional convention, none whatsoever. Here are the things that we don't know about a constitutional convention. First, how many delegates will there be? Second, how will they be chosen? Third, what will the rules be? Who will be in charge? How will the matters be considered? By what vote will there be to adopt these amendments and changes to the Constitution? Who will pay for the Constitutional Convention? Who will pay for the expenses of the people at the Constitutional Convention? Will the states get to have delegates in proportion to the number of residents they have? Or will it be one delegate per state? Or, as Louisiana has decided, if there's a constitutional convention, there'll be 5 delegates. So let's assume there are 5 delegates per state. In Louisiana, the commission that they said there'll be a commission, and the commission will put together a panel of 5 people, 3 of whom have to be legislators. Who are the other 2? Who are in the legislatures of the United States? How many women are in the legislatures of the United States? How many African Americans? How many Asian people? How many Native Americans? Very, very few. How many young people? It depends on how you define young, because, for example, in my firm, I talk about my young partners, they're 50. So what we face is, if there is a constitutional convention, a prospect of a slight repeat of what happened at the time of the Articles of Confederation, the meeting. That is, a bunch of white men will get together to talk about amending the Constitution however they want. Now, others would say, well, no. These calls for a constitutional convention are only about adopting a balanced budget amendment. I mean, that's what it's about. It's only about a balanced budget amendment. But as we know from the only other constitutional convention we had, it doesn't matter what it's about. Because once the delegates are there, they can do whatever they want. Others say, well, but Congress can do something about it. The courts can do something about it. Not really. Congress has nothing to say about a constitutional convention under the terms of the Constitution. There's nothing which gives the courts any jurisdiction over the Constitutional Convention. The Constitutional Convention is supposed to be a democratic process where the will of the people is expressed through the aging white men who show up there. What's the danger of this? Well, we have to take a step back and look at the current political environment and who is seeking a constitutional convention. There are 2 organizations which are really pushing a constitutional convention and have really pushed states to adopt these resolutions. One of them is the American Legislative Exchange Council, which is called ALEC. And the other is, it's called the Convention of the States. There are some names associated with these organizations that you might be familiar with. Walton, that would be Walmart. Coke, that's not C-O-K-E. DeVos. Those people and others are have a certain ideology, and the ideology is called libertarianism, maybe. It's really called, let's get the federal government out of our pocketbooks. And the danger here is because there are absolutely no rules that apply to a constitutional convention, absolutely none, that the agenda of such a convention will be driven by a small group of highly motivated, highly ideological billionaires. Now, why am I concerned about that? Because if we look at the current political environment, we see on a micro level, which is macro for our daily lives, but a micro level compared to a constitutional convention, that that same strata of people have a significant influence on the current political environment. And it's driven by, that is, it's really allowed by the Citizens United decision, which opened the floodgates of money into the political system, and by gerrymandering. So gerrymandering and money are the key to why a constitutional convention is so dangerous. And let me explain the connection between those two things. Let's take Wisconsin, for example, which has extreme gerrymandering. All right, so we have extraordinarily concentrated Republican districts and extraordinarily concentrated Democratic districts. There are more Republican districts than Democratic districts. That's the way the map was drawn. Well, what's wrong with that? What does that cause? What it causes is ideological orthodoxy in the Republican districts, because no one who is in a highly gerrymandered district, when they're in the majority, can deviate from the majority opinion because they can't make a compromise. Consequently, if they do deviate, these moneyed interests will run people against them in primaries, and because very few people vote in primaries, they will be defeated. Consequently, the existence of these large amounts of money enforces ideological orthodoxy. You can see this across the political spectrum. All right, so now cast forward to a constitutional convention. What would happen at a constitutional convention? Well, we know when politicians get together, they make deals. So what are the issues that might happen? What might come up? Well, let's say some of the issues of the day. Birthright citizenship. All right? People don't like birthright citizenship anymore. There's a lot of people say we can't have birthright citizenship. We have people coming here on vacation to give, to have babies. We can't allow that. Well, birthright citizenship is kind of important to all of us, because if you don't have it in the 14th Amendment, which, by the way, is the essence of the Constitution, any of us could have our citizenship thrown out. But let's say you trade off birthright citizenship for something else. Let's say you trade off birthright citizenship, for let's say the right to abortion. Let's say you trade off limiting the Commerce Clause for something else, like protection for LGBTQ people. And let's say you put together a package of things that keep people from opposing the things that they don't like, because there are still things in there that are good that they like. And you could end up with a package that has the ideological things that the billionaires want, which really is limitation on the Commerce Clause, limitation on federal regulation, and if you add into the mix the First Amendment, and you say, well, yeah, we have to not respect the establishment of religion. Maybe we could change that a little bit. Maybe we could say, this really is a Christian country. Now, just imagine if that's on the ballot. Say, well, it's a Christian country, but we can have our other religions, but really, this is a Christian country. Now, you put those things all together, you roll them together in a package. You've got the things the billionaires want, you've got legislatures now, which have to then approve this new constitution with a 3/4 vote. You got gerrymandered legislators. And there's no time limit, by the way, on when the states can consider this. You got gerrymandered legislators. You've already got 27 legislatures that asked for this constitutional convention. You've got a demand for ideological purity. You've got the money to enforce it. I contend that you then have a dangerous, volatile political situation that will tear this country apart. But it might also result in a brand new constitution. A constitution which will not have been interpreted by the Supreme Court. And in fact, it might not even be allowed to be interpreted by the Supreme Court. Because, as I think all first-year students know, or at least the students who have taken constitutional law, the Constitution doesn't say that the Supreme Court gets to interpret the Constitution. It's Marbury versus Madison that says you can interpret the Constitution. And when you have a new Constitution, Marbury versus Madison means nothing. And that new Constitution could say, you know, the Supreme Court can advise Congress as to its opinion about whether something is constitutional, but it will be Congress that decides whether it's constitutional or not. All right, so this is a scenario. I don't know whether this would happen, but I will say the Constitution is a sacred document. Is it perfect? No. It has great imperfections. But we have to be vigilant. We have to be vigilant. We have to look at a big picture and recognize that there's a danger to that Constitution, and we have to make sure that it is not allowed to develop, that that danger does not come to fruition, because we will live to regret it. So, my parting statement is, when it comes to something like the Constitution, and you're a lawyer, be insolent. Thank you.